Welcome, everyone. I'm glad you're here. I'm Lisa Goodhart from Fitch Law Partners in Boston, and it's my privilege to serve as co-chair of the Access to Justice Commission, together with Judge Valerie Eurasius. And we are very excited to present today's program to you. It's part of our year-long celebration of the Commission's 20th anniversary. We have a lot of substance lined up for you, and I hope you picked up a copy of the program on your way in, or you can look over the shoulder of a neighbor so you can see what we've got in store for you. So the theme for today's program is technology and transformation, and we're going to be focusing on the relationship between technology and access to justice, and our mission of promoting access to justice for everyone. Our speakers are going to help us take stock of where we've been over the last 20 years and where we are today. And we'll be hearing not just about the road that we've traveled, but we'll also be giving thought to where we're headed and to the questions that we should be asking as we try to shape a more equitable future. So we're going to get started with no further ado, and I'm going to begin. It's my privilege to invite the Chief Justice of our Supreme Judicial Court, Kimberly Budd, to offer some introductory remarks, and I will ask you to join me in thanking the Chief and her fellow justices, both for making this beautiful courtroom available for our program today, but more importantly, for their steadfast commitment to access to justice. Chief, thanks.
Good afternoon, everyone. On behalf of the justices of the Supreme Judicial Court, it's my pleasure to welcome all of you to today's symposium. Welcome to the many past and present court leaders and members of the judiciary in attendance today. I especially want to welcome our keynote speaker, Attorney General Andrea Campbell, and all of our panelists. Thank you in advance for taking the time to share your insights with us. I'd also like to thank the co-chairs of the Access to Justice Commission, Judge Valerie Eurasius and Lisa Goodhart, its director, Deb Silva, and everyone who has worked with them to prepare for this event. 20 years ago, the justices of the SJC created the Access to Justice Commission to provide leadership, vision, and coordination for the many organizations and individuals dedicated to providing and improving access to justice for people who cannot afford legal representation for their essential legal needs. Since its inception, the Commission has brought together leaders from courts, legal aid organizations, bar associations, law schools, community groups, and other stakeholders to collaborate on identifying obstacles to access to justice and developing creative solutions to overcome those obstacles. This collaboration has produced significant reports, such as the landmark Barriers to Justice report, issued in 2007 under the leadership of the Commission's first chair, retired SJC Chief Justice Herbert Wilkins, who passed away earlier this year. And 10 years later, the Commission issued another collaborative report, the Massachusetts Justice for All Strategic Action Plan, under the leadership of its then co-chairs, SJC Chief Ralph Gantz and Sue Finnegan. But Chief Justice Gantz used to say that he didn't want reports written only to gather dust on a shelf. He wanted action. And consistent with that goal, the Commission has worked closely with the courts and other stakeholders to put ideas into action. For example, the Commission encouraged and supported the trial court's creation of court service centers to provide legal information to unrepresented litigants and help them filling out forms. The Commission has also developed new sources of funding for legal aid, such as the voluntary Access to Justice bar registration fee. And the Commission has worked to expand volunteer legal assistance for unrepresented litigants and the organizations that serve them. One of the most innovative examples is the Access to Justice Fellows Program, through which retired attorneys and judges provide pro bono services to legal aid agencies and other nonprofits. We're very pleased to be celebrating this year's Access to Justice Fellows as part of our program today, and you'll be hearing more about them later this afternoon. If you'd like to learn more about the Commission and its activities, I hope that you'll take a moment to look at the posters that are on display in the Great Hall, down where the visitors' film is located. They highlight some key aspects of the Commission's work over its first 20 years. Today's symposium carries on the Commission's tradition of convening and collaborating with other stakeholders to develop action-oriented strategies to improve access to justice. And it comes just at the right time. Thanks to the funding from the legislature and the hard work of Chief Information Officer Steve Duncan and his team, we are making real progress in improving our tech infrastructure in the court system. Meanwhile, the trial court has created a new Office of Access, Diversity, and Fairness that includes a department dedicated to access to justice and the user experience. And earlier this year, the justices of the SJC asked the Commission to study potential ways to harness generative AI tools to increase access to justice while minimizing the disparities caused by its cost. In addition, law schools and legal aid organizations have been developing innovative websites and applications that use new technology to support access to justice. And they've been collaborating with the courts on programs such as a guided interview for preparing and filling out eviction sealing petitions. So there's lots of positive momentum behind the efforts to use technology to improve access to justice. And it's important that the Commission is focusing on this topic because it will be particularly sensitive to a critical concern that's sometimes overlooked. To use technology to improve access to justice, we must also improve access to technology. For all these reasons, it's fitting that in the celebration of its 20th anniversary, the Commission is leading this discussion of technology and access to justice, which will play an ever-increasing role in shaping the experience of court users in years to come. Thank you.
Thank you, Chief Justice Budd, for those wonderful remarks, and thank you for your ongoing and continual support of the Access to Justice Commission. We are inspired by your commitment to equal access to justice and your visible support today and the work that you do in leading our courts every day, so thank you. Welcome, everyone. I am Valerie Eurasius. I'm a Superior Court judge, and it's my privilege to lead the Access to Justice Commission as co-chair along with Lisa Goodhart, as you heard, and our whole leadership team, including Deb Silva, including Chip Finney, who I'll say more about in just a moment. So what I want to tell you is that Massachusetts is one of 38 states that is fortunate enough to have an Access to Justice Commission. This symposium is one example of what the Commission does best, and that is bring together the courts, the Access to Justice larger community, and community partners. We look for issues and problems, and then we brainstorm and find ways that can actually solve them working together. We do this by learning from best practices all around the country. So when I saw the RSVP list for this symposium, I realized how hopeful I feel, because what it's important to know is we have everyone we need right in this room to make the changes. And so all the people we need, all the talents we need, we have right here in Massachusetts. We have speakers' bios outside, so I'm not going to say anything about those, but my 5 minutes is going to be used acknowledging who's here, because I think it's important that everybody know who's here in the audience. You know who the speakers are going to be. And please forgive me if I leave anyone out, but I'm going to talk about categories because I think it's important to know who we have the opportunity to be talking to today and really think about how we can use the opportunity of this symposium. So first, let me tell you, we do have a very special guest in attendance, and that is the highly acclaimed retired chief of the SJC, Chief Justice Margaret Marshall. You know that the commission was created 20 years ago, as you've heard. That happened to be during Chief Justice Marshall's time as chief, and that was not a coincidence. She was always committed to access to justice, and her vision and leadership helped to bring the commission about. So thank you, Chief Justice Marshall. We owe you a huge debt of gratitude. Thank you all. So next, I'm going to start going through listing some of the people I want everybody to realize are here, but I'm going to ask you to just hold your applause for everyone else, if you would. In addition to Chief Justice Budd, we also have, I believe they're all here in spirit, but I think we have 4 SJC justices here in person, which we greatly appreciate. I believe it's Justice Stewart, Justice Windland, Justice Gaziano, and I think also Justice Willahosian may be here. We have members of the Appeals Court, including Chief Justice Blake. We have the Chief Justice of the Trial Court, Chief Justice Brieger. Thank you for being here. We have the Court Administrator Ambrosino. Thank you. Dr. Scruggs, you heard about earlier. We have Chief Justices of the BMC, rather, Chief Justice Lyons. We have Chief Justice of the District Court, Chief Justice Fortas, and other chiefs may be watching, or they may be doing the business of the court right now. We also have a number of trial court judges. We have court clerks who have come. We appreciate your attendance. You do so much. And we have a number of deputy court administrators who are so critical to what we're doing with technology. We have other very special court employees. Thank you to the whole security staff of the SJC for making this happen. The SJC has an amazing staff, including security and many other people as well, who gave us this wonderful setup and are providing everything that we need. It is being live cast, and so we welcome all of you who are watching remotely. Let me mention who we have here, and I'm just going to give you some examples. Again, I can't mention everybody, but I do think it's important to welcome the larger Access to Justice community. And I'm going to start with Lynn Parker from the Massachusetts Legal Aid Corporation. We have civil legal aid providers, we have nonprofits, we have practitioners, we have academics, we have community partners. Let me give you just a few of the community partners and legal aid providers that we have here. We have people from Mass Law Reform Institute, Veterans Legal Services, Greater Boston Legal Services, Community Legal Aid, Volunteer Lawyers Project, Justice Bridge, Casa Marina, Mass General Brigham, and so many more. We have Bar Association leaders in attendance. I know we have the Mass Bar President, Michael Hayden. Thank you for being here. We have Susanna Thomas, the Executive Director of the Mass Bar Foundation. I know we have other officers here as well. We have the leaders from the Boston Bar Association and the Boston Bar Foundation. I believe we have President Sumaner. I believe we have Rich Page, and I think we have Michael Avitzer as well. We also have members and leaders of our great affinity bar associations. So let me tell you about the production team that put together this event. Our 20th anniversary task force of the commission was led by J.D. Smealy, Judge Julie Bernard, and Lisa Goodhart. They did a fantastic job for the whole year. This is just the culminating event. We have all of our commissioners that are appointed by the SJC. We have our terrific commission director, Deb Silva. We have Chip Finney, who is the SJC's chief counsel of judicial policy and an extraordinary part of our leadership team as our liaison. Susan Gedrick and Lawyers Clearinghouse, with a special thanks to Susan for putting on and deciding to bring together the Fellows Program with the Symposium. We appreciate everything that Lawyers Clearinghouse does for the Access to Justice Fellows, which we'll talk about more later, and a special thanks to Mintz and Lawyers Clearinghouse for hosting the reception that's going to follow from 4 to 5. I'm going to save for last the person who has done the work of about a dozen people pulling this whole thing together, which is Lisa Goodhart, my co-chair. And if any of you have worked with Lisa before, you know what I'm talking about. She really does the work of about a dozen people. So thank you all for making today a way to reflect not only on our history and where we are now with the intersection of technology and the access to justice, but also to envision together where we can go in the future in ways that we might not be able to fully envision on our own. And with that, I believe we're going to show you a 3.5-minute video that we put together as part of our 20th anniversary, and we will be getting very soon to our keynote speaker. To accomplish the things that are in our mission statement at the Commission, we need to be working with bar associations in Massachusetts. I'm Valerie Euratius, a Superior Court judge and also the current co-chair to the Access to Justice Commission in this 20th anniversary year.
Hello, my name is Mary Jane Benner Brown, and I am currently co-chair of the Massachusetts Access to Justice Commission.
Hello, everyone. My name is Serge Georges Jr., and I'm an Associate Justice of the Massachusetts Supreme Judicial Court. And it's a real honor for me to be part of this celebration marking the 20th anniversary of the Massachusetts Access to Justice Commission. Let me highlight for you 5 major areas where the Commission has made a real difference. First, funding for civil legal aid. The Commission secured approval for a voluntary registration fee and a pro hoc vice fee, both dedicated to legal aid. It also helped direct millions of federal dollars to support victims of crime through civil legal aid services. Second, pro bono services. The Access to Justice Fellows Program engages, among others, retired attorneys and judges to give back through pro bono work. The Commission also supported court-based initiatives and launched a statewide appellate pro bono program. Third, help for self-represented litigants. The Commission helped expand the housing court, establish court service centers, and improve forms and websites to serve people better. It also backed masslrf.org and helped develop the judicial guidelines for cases involving self-represented litigants. Fourth, racial equity in the civil justice system. In 2020, the Commission launched the Racial Equity and Justice Committee. It partners closely with the Trial Court's Office of Access, Diversity, and Fairness to help drive change. Fifth, leadership in times of challenge. The Commission helped develop the 2017 Justice for All Strategic Action Plan, and during the pandemic, it quickly created a task force to share resources and best practices, leading to a 2020 report.
What the mission of Access to Justice is now, a lot of it is building an infrastructure to support people who don't have representation in the court.
So much of the Commission's work is behind the scenes and involves making connections, amplifying ideas, and fostering collaboration. And I see Commission fingerprints on many things. One example is the Tax Lien Foreclosure Clinic, which is now run by the Lawyers Clearinghouse. Sue Finnegan, a real force. She was involved, among others, in leading, actually, incubating and establishing the Access to Justice Fellows Program, as well as the Civil Appeals Pro Bono Program through Tenacity and Smarts, and by bringing others together in collaboration.
What kind of a Commonwealth would we be if we did not protect the rights of those in need by providing them with adequate legal services?
The enormity of the work ahead of us, combined with the overwhelming knowledge and resources in the Massachusetts legal community, reminds me of a Nelson Mandela quote: "It always seems impossible until it's done."
Happy 20th anniversary to the Massachusetts Access to Justice Commission. And here's to the next 20 years. Thank you.
I now have the pleasure of introducing our keynote speaker, Attorney General Andrea Joy Campbell. Attorney General Campbell was sworn in to be the 45th Attorney General of the Commonwealth in January of 2023, and she's the first woman of color to win statewide office in Massachusetts. She's committed to serving the people of the Commonwealth, and it's clear from her office's work that she cares deeply about access to justice. This is a professional commitment for her, but it's also a very personal one. Her journey to her current position did not take a traditional path. And so rather than go on and on about her remarkable educational and professional credentials, I want to tell you a bit about her life story. And we're here for access to justice, and part of that is taking a close look at the hard challenges that real people face and the combination of grit and helping hands that enable them to meet those challenges. Andrea Joy Campbell was born and raised in Roxbury and the South End neighborhoods of Boston. Her mother passed away in a tragic car accident on the way to visit her father in prison when Andrea was only 8 months old. While her grandmother did the best she could to raise Andrea and her siblings, she occasionally struggled with alcoholism. So Andrea and her brothers would spend their early years moving between residence and foster care until their father came home from prison and she met him for the first time at 8 years old. Life was not easy. Her family was poor and they relied on public housing and food assistance. And her father, who had worked hard to rebuild his life after prison, did not live to see Andrea graduate from college. He died suddenly when she was 19 years old and a sophomore at Princeton University. Her twin brother, Andre, would later die at just 29 years old in the Department of Corrections custody due to receiving inadequate health care as a pretrial detainee. But through all of this, Andrea persevered and turned pain into purpose. After graduating from Boston Latin School, she went on to become the first in her family to graduate from college and law school, receiving her degrees from Princeton and UCLA. After earning her law degree, she worked as a legal services attorney. Let's hear it for legal services attorneys. She defended the rights of children and their families, and particularly those with disabilities. Andrea also practiced law in the private sector and ultimately left to serve the public as general counsel at the Metropolitan Area Planning Commission. She served as legal counsel to Governor Deval Patrick, and in 2015, successfully ran for the Boston City Council. In 2018, she was unanimously elected as City Council President, the first Black woman to hold that title, and in 2022, she was elected as our Attorney General. So as her story makes clear, Attorney General Campbell has a deep understanding of what access to justice can mean in the lives of people who face profound challenges with very few resources. Please join me in welcoming her. Thank you.
Thank you. Wow. Thank you, Lisa. Everywhere I go, I have to take you for all of my introductions. Thank you for your leadership on the commission. I'm grateful, and you have been a supporter since my transition committee support, you name it. So I'm grateful for your continued support. Thank you for the warm introduction as well. Justice Eurasius, thank you for your leadership, of course, on the commission and all that you do on a daily basis. Chief Justice Bud, thank you for just being a friend, a mentor, all the things. I won't go on, but thank you. And of course, to everyone who is here, all of the justices, former, current, legal services organizations. I see Mai Chai from my team. Anyone who's on the AGO team, can you just raise your hand? I see some of our comms folks too, but literally raise your hand. Raise it high like you're proud. Mai Chai obviously is on the commission. We have other lawyers and team members who are as well, but just, I don't do this work by myself. I do it with an incredible team, so I always want to acknowledge them. It's really important. Just delighted to be here with all of you. I know so many of you, and I have gotten to know so many of you over the years, so just grateful. Before I get into the topic of the day and what we're here to talk about, most importantly, technology, I'd be remiss, given where I am, this historic institution, where we are, and who's in this room, given the climate we are in, and I'm not going to get political, but I'm going to be factual, of course. It is a tough time, to say the least, an unprecedented time. And the rule of law, of course, is under attack. The Constitution, you name it, lawyers under attack, judges, legal service organizations. So all of the work that we do in our office on your behalf, it's just that, on your behalf, but it's also in collaboration and in partnership. Thank you to each of you and to those you represent. Please extend this gratitude to your teams for everything you're doing to stand up for the rule of law, making it applicable to everyone regardless of their political affiliation. because we are, at the end of the day, the best state in the country. And everyone is looking to us to see what we're going to do, not just through this commission, but everything that we're doing in our individual capacity, in our institutions. And I'm just grateful to be a part of it with each and every one of you. So I'm looking around over here and over here, extending that gratitude far and wide. Thank you for having me, but most importantly, the gratitude goes right back at you for everything you're doing to represent the legal system as a whole. I see you, I honor you, and I am grateful. So thank you. And of course, I want to thank this commission and like I would say, was Serge, who I've known for a long time, the justice said on the screen, congratulations on 20 years. It doesn't happen by accident. It's the intentionality of folks who believe in the work of the commission. And so I'm grateful to each and every one of you, including past co-chairs and those who served on the commission before. 20 years is a big deal, so thank you for everything that has been accomplished in 20 years. I'm also grateful, of course, to be here to acknowledge the theme of the day, which is, of course, moving access to justice forward in the 21st century, but most importantly, technology and transformation. And we can talk about technology transformation, but what does it actually mean? I want to give some context. 20 years ago, when this commission was first established, no one could have ever predicted the role technology would play, not only in our legal system, in our justice system, but in our daily lives. For context, in 2005, Apple just released the iPod Shuffle. Some of us in the room know what that was. YouTube and Reddit were considered startups. Gmail had just opened to the public, and the Motorola Razr, yes, that flip phone from way back when, was the best-selling phone of the year. And I didn't have one of those Razrs. My cell phone was a flip phone, but it was quite thick, and I think the battery had to be charged every few hours. And it was probably after I just replaced the pager that I had, for those in the room that remember those, and all the codes that you had when you had your pager. And I think AOL was actively still being utilized. If you still have AOL, I'm going to pray for you. So a lot has changed in 20 years. This makes today's symposium not only important, but essential, an opportunity to reflect on how far we've come and, of course, where technology can take us next. Technology, when used with intention and placed in the right hands, can be a powerful force for public safety and for justice. Within the legal setting, modern technology has done many things, including helping us solve crimes quickly and accurately, allowing us to allocate resources more efficiently, addressing language and accessibility concerns in real time, and ensuring greater access to justice than ever before. Digital platforms make it easier for people to access information, file documents, navigate the legal process to better understand their rights, and so much more. Remote hearings enable greater flexibility, not just for the people we serve, for lawyers, for witnesses, for litigants who may otherwise struggle to attend court in person due to geographical barriers, because regional equity, even in Massachusetts, is real. Some folks in this room don't know where true Western Mass is. You should work on that. In addition to geographical barriers, time constraints, financial constraints, flexibility if something goes terribly wrong for a loved one you serve or a child. In my own office, we are constantly working to improve our use of technology to help people have more channels to reach us, as well as to achieve justice for our residents. For example, we are constantly experimenting with technologies to help us reach more people through webinars, surveys, other digital tools to supplement the in-person outreach that the office does every single day. And recently, we hired a data scientist to help us digest complex cases and cases all across the office. These are 21st century developments that have certainly opened the door to greater equity within our legal system. Modern technology in the legal setting is undeniably powerful and essential. But like anything else, it doesn't come without challenges. With greater power, of course, comes greater responsibility. The use of these tools must be matched with strong oversight and transparency. To the lawyers in the room, of course, but also members of law enforcement who are also in this room, we must not trade constitutional rights for convenience or even efficiency. Any use of technology, whether it's surveillance, predictive algorithms, which I've learned a lot more about lately, or data collection, must comply with our privacy laws and avoid discrimination. Our SJC has certainly led the way. You have led the way, ensuring that constitutional safeguards extend to new technologies. And since half the battle is just making sure our residents and businesses know what they can and cannot do, my office has also issued guidance which complements what our courts are doing every single day on state consumer protection laws and how, for example, they apply to artificial intelligence. Believe it or not, our office was the first AGO in the country to issue such guidance. So we want to match, of course, what our courts are doing with all of you are doing in terms of our innovation and leadership. As technology rapidly evolves, it can be incredibly difficult to ensure that our laws and regulations keep up. But what it must do is, of course, maintain public trust and fairness. Instead of shutting the door on innovation, as some may want to do, I challenge all of us, just like we did with this guidance, to allow this moment in time to guide us, to ensure it, of course, advances justice, but to ensure the public gets to inform the guidance, the regulations, and everything that we're doing to safeguard these new technologies. This commitment to responsible innovation extends far beyond the courtroom, of course, particularly when it comes to our young people. I'm not just an AG, I'm also a mom of two beautiful, yes, they are beautiful. They say the darndest things. But two beautiful young boys who I think about every single day, especially when it comes to technology. It's no secret that in our country, including here in Massachusetts, our young people are facing a mental health epidemic, spurred by some of the most obvious challenges with technology and social media. And I refuse, and I would say my team agrees, my child would agree, given the bureau that she leads, we would say that we refuse to tolerate a future where companies exploit young people for profit, while not implementing the same safeguards that will be discussed today by this incredible commission. So we're taking this on head on. While we, of course, are focused on everything happening at the federal level, our proactive work has not slowed down. It has only continued. Our lawsuits, for example, against Meta and TikTok, two of the biggest social media companies in the world, those lawsuits continue. In addition to those lawsuits, we recognize, and as we go out to talk about these lawsuits, we recognize that social media can foster connection, creativity, and community. Yet we also know without question that excessive social media use contributes to declining school performance, disrupted sleep patterns, heightened anxiety, depression, self-harm, and diminished self-esteem, especially for our young people, but also for some adults. It takes time and attention away from healthy off-screen activities like going outside, and I blew over here, I didn't walk, enjoying volunteer work, extracurricular activities, getting to know folks, the humanity in other folks, learning how to have a conversation, sitting down to dinner with friends and families, and so much more. So we are focused on that because we think in this moment in time, it's critically important and absolutely connects and complements what the commission is doing every single day. But we also know lawsuits can take a really long time. So we're showing up in the State House to also complement the work of the commission in focusing on our young people in particular. We filed a bill called the Study Act, which we think is really important to ban the use of cell phones within our schools. It's not an easy Study Act. We're pushing for the Study Act, but it's not an easy conversation, but we think it's important to ensure young people, as they're going to school, are actually learning about our courts, learning about civic engagement, learning about this commission, for example, learning about all the ways in which they can inform public service, be a part of public service, and most importantly, thrive and reach their dreams. As we do legislative solutions and we think about lawsuits in which to complement the work of this commission, we also think it's equally important, and I will end on this note, particularly in the context of young people, that everything that we're doing be informed by the next generation of leaders, by young people. I was really proud that we launched what we call our AGO AG Council, AG Youth Council. Our second cohort just started. It's in its second year. It's a youth council made up of what? Young people. Younger than me. I still think I'm young and fabulous, but younger. The Youth Council is comprised of 26 young people between the ages of 15 and 18 from all across the Commonwealth. We had hundreds of young people apply to be a part of this council to inform the work that we do every single day on their behalf. And these are young people, not only from our traditional cities and gateway communities, from our rural communities, our urban communities, and our suburban communities, and everywhere in between. Our young people should have a seat at the table, and we've been encouraging folks as we talk about technology, what does it mean to incorporate their voice? They know more about it, especially these platforms, than we do at times. And most importantly, we're doing all of this for our children and the next generation, so we also think it's important for them to be a part of the conversation. And of course, technology's risks extend beyond social media. The increasing spread of computer-generated imagery, commonly known as deepfakes or deepfake pornography, is amongst the most urgent and disturbing threats we are seeing. In August this year, my office led a bipartisan coalition of 47 AGs, obviously across the aisle, bipartisan work, in calling on major search engines and payment platforms to take action against deepfakes, and will continue to push these platforms and to push to hold them accountable. This new reality we're facing, one where anyone can create realistic storylines or images with the click of a button, is a grave harm to human decency and dignity, and its urgency cannot be overstated. We want to continue to be a partner with folks in this room on that very work as well. I bring up some of these cases to illustrate a broader reality. Technology is shaping not only how crimes occur, but how they are uncovered, investigated, prosecuted. How do we hold institutions accountable, companies accountable, anyone accountable for the harms in which they may be using technology to perpetuate on our residents, and not just here in Massachusetts, but across this country? A decade ago, after the commission was established, digital threats like data breaches, cybercrime reached historic levels at an alarming rate. Innovations in technology can present themselves as opportunities for bad actors to create new barriers, deepen inequities, and inflict harms that we can only begin to dream to understand. Data breaches, of course, we also as an office are addressing, and I can go on and on about that, but I won't because I don't have enough time. But cyber crimes already cost our country billions of dollars each year. And it's estimated that by 2027, the annual global costs of cybercrime will rise to nearly $24 trillion. We certainly see our role in that as being substantial, and our office will continue to work with you. But we also see the work of this commission in ensuring access to those who need it the most for these types of crimes is addressed. And so I'm grateful for every speaker who will show up today, of course, and participate, but to enlighten all of us, including my team, on ways in which we can partner in this work. Lastly, I will end on this note. Like I said at the beginning, it is an honor and a privilege to be your Attorney General. I never take it for granted that I have the best job in, forget Massachusetts, in the world. But it's not about me. It is about service. You have a partner in this office on everything you do, not just the commission's work, and I'm grateful for it, but on everything that comes up. We want to be accessible, we want to be useful, and we want to be responsive. I have incredible team members serving on this commission. Thank them, of course, but also know that they are partners in this work with us. And please stay in touch with us. We support you in everything you do to make justice more accessible through innovative technology, while at the same time ensuring it is not harming anyone in the process. And like I said at the beginning of this, thank you for showing up in the roles that you have, for everyone who works in our judicial system as a whole. I am grateful. Current, retired, we need all of us. So thank you all. Continue to take care of yourself, your physical health, your mental health, your spiritual health. That's equally important. And thank you again for having me today.
Thank you, Attorney General. That was wonderful and very inspiring. My panelists, where are you? Come on up. Hi, good afternoon. As your program informs you, I am Gordon Shar. I am the Director of Client Access for Community Legal Aid, and I'm also a Commissioner at the Access to Justice Commission. And I'm going to be your moderator for our panel presentation, which we are calling, Where Have We Been and Where Are We Now? I'm going to continue on a theme that was started by our Attorney General. In the late 1990s, I acquired my first mobile phone. And here it is. It was a hand-me-down from my wife, who insisted that I start carrying one of these around in my pocket, even over my protest that I didn't want this thing buzzing around. Look how tiny that screen is. Here is my phone today. And it is my lifeline, literally, to the world. I don't know how I would get by without it. And I mention this because it illustrates how rapidly technology is changing how we interface with information and even with each other. When I started working as a legal aid lawyer in the mid-90s, the internet was just emerging as a tool to help clients. I'll throw out a few more technology trivia bits. Google started in 1998. And it's only been about 20 years since 2004 since Facebook reshaped how we communicate with each other. And I'm struggling now with remembering how we used to educate our clients before the internet. Back in the late 90s, few clients had email addresses, much less access to the internet. And now we have all these modern conveniences that help me do my legal work. In the old days, if I needed to see a court file or file a document with the court, I would need to make my way over to the courthouse. Now we have mass courts and e-filing. And the idea that litigants could meet with the judge over the internet has been transformative. But I still have to say we have a lot of work to do, even with all of these modern conveniences, to make sure that these tools are in fact working and are accessible to our self-represented litigants, the ones that are not able to get a lawyer. But to help us remember where we've been and where we are now, I would like to turn it over now to our panelists. To my left is Steve Duncan. He's the Chief Information Officer for the Massachusetts Judiciary, where he's leading statewide efforts to modernize the courts through technology. Before joining the Judiciary, he served as IT Director at Harvard's Kennedy School of Government and spent more than a decade in technology consulting across multiple industries. Steve, why don't you kick it off? She's gonna, well, let me introduce Lee. Okay, well, that's a change in the order, but Lee Kavanaugh is the Director of Research and Planning for the Trial Court and is the Executive Director of the Massachusetts Sentencing Commission. She first joined the judicial branch in 1995 as a research analyst. Lee previously conducted research for the Boston Public Schools and the Massachusetts Department of Youth Services. And I'll save my introduction to Brian when he speaks. You want to join us up here?
Thank you, Steve. It's wonderful to be here, and thank you for inviting me to speak. When I got the invitation, I was a little confused in what I would do, what my remarks would be, and that's because as a researcher and as the Director of Research for the trial court, we touch many things. We touch many issues within the trial court, gathering data for commission members, gathering data for our leadership. And so we touch a lot of things. We know a little about a lot of subjects. But I'm also very proud of the development of our research department over the years. And I think research is essential to access to justice. It helps us identify areas, monitor areas, make us accountable. So what I'm going to do is a little bit of each. So one of the first things I did when I got the invitation to speak, I actually went back 30 years because I just celebrated my 30th anniversary with the judicial branch. So I went back a little bit further. And one of the first things I did was I went to the State House Law Library and I got a copy of the 1995 annual report of the trial court. And it was a fascinating read. I was fascinated with it. And one of the things that fascinated me the most was the issues are still the same. We're still working in the same areas. We've advanced our tools and our focus has narrowed, but we're still doing the same things. And so, for the most part, the activities that the court was involved in 1995 involved making courthouses and the legal process more accessible and easier to navigate. They wanted to make court operations more efficient. That's what the initiatives were directed at. They wanted to respond to the difficult issues of the day that sort of underlied some of the cases that were coming into the courthouse and that court users were struggling with. And it was also very interested in improving diversity, equity, and inclusion within the trial courts. And so if you've ever seen the annual report from way back then, it presents highlights. And so I thought I'd mention a couple of the highlights to you because it's a lot different from 1995 to now. So one of the major highlights they noted in the 1995 report was that our Court Facilities Bureau had procured a machine that made signs so that they could hang them in the courthouse. Today we have a digital sign initiative. It's a little delayed because of the budget, but its intent is to provide electronic signage containing organizational content, wayfinding, real-time docket information, and directories. There is one being piloted now in Chelsea, and once the budget looks a little bit brighter, it will be expanded across the trial court. One of the other things, another matter that the court was highlighting as a major accomplishment of the year was our law library. It had developed a catalog, and that was recognized as being a very good catalog. And it also developed a brochure on how to navigate the maze of the trial court, which I thought was very appropriate. Today, in addition to 15 physical libraries, we have a virtual library. We have online live library services, including chats, email, and Zoom. We have full research capabilities and full research support in our libraries today. And in a poll done by Lawyers Weekly, of the 5 largest research entities, I guess you would say, legal research entities in the state, the trial court law libraries came in second. And it's also the only free legal research entity in the state. So, what a wonderful, wonderful progress to have made. Interpreter services, 1995, 22,000 interpreted clients or events that they had to interpret for. 24 languages. Spanish accounted for 76%, and the next 2 languages was Cambodian and Vietnamese. The latest numbers we have for interpreter services in the trial court, over 150,000 interpreting events in the past year. 100 languages. And Spanish is now 50%. And the other next 2 are Portuguese and Haitian. We also have American Sign Language interpretation now, which we did not have in 1995. And then an additional initiative that was underway in 1995 was a portal, some sort of portal, so folks could look at cases. It was piloted in the Superior Court. They picked the 25, I believe, the 20 or the 25 busiest law firms in Boston, and 2 newspapers. I don't know what newspapers they were, but they picked 2 newspapers and gave them access to Superior Court cases so they could see what was going on. Very, very forward thinking. Well, our portal today, that is both public portal and a lawyer portal, according to the latest numbers, 6.9 million internet hits per month on the public portal, 1.7 million per month on the attorney portal, and 465,000 per month on the terminals that are within the courthouse. So there's been a lot of movement in the numbers, a lot of movement in the technology that's being used and what's available to anyone who walks into the courthouse. I was just so taken back by seeing so many familiar things that we're doing now that with, good, smart people committed to justice for all have been thinking about all of these years. Other things that were mentioned, benchtop displays for judges. Well, we're working on that as well. Tracking workforce diversity. Well, we do that now. We have diversity dashboards. We have a diversity report. And they're talking about integrated criminal justice tracking, which was an executive branch initiative, but that was just completed this year. Very, very interesting. And they also were dealing with some of the same things we were dealing with today. One of the big issues in 1995, they had over 20,000 evictions, which is a pretty sizable number compared to what we're seeing today as well. And their major issues that they were trying to address through training of staff and judges were issues related to unemployment and a very poor economy. There were surges in small claims and debt collection. And again, those are many of the things we focus on today. So that's sort of, I thought that was fascinating. I couldn't let the numbers go. I am a researcher. I do like numbers. And so I found it really interesting to see these changes over time. But at heart, I'm a researcher. And I'm now the director of research and planning for the trial court. But we haven't always been the Department of Research and Planning for the trial court. We did start in 1995, but we started on the criminal side. We were the staff to the Massachusetts Sentencing Commission. We were created by law the commission was created by law to establish sentencing guidelines that were fair by race, gender, and location across the state. We needed data. It was the law was very data focused, and that we needed data in order to do our work. I was a member of the staff. We need a lot of data to do that work. And interestingly enough, we could not get that data through the trial court. It was not available. So we ended up going to the Department of Criminal Justice Information Services, DCJIS, and that's where we got our data to begin our work for the Sentencing Commission. So that went on for a few years. The guidelines never passed, and our interest in the guidelines dropped. And so our staff was sort of looking for work. And interestingly enough, and lucky for us, our chairman was Justice Robert Mulligan, who for a time being was the Superior Court Chief Justice, and then became the Chief Justice of Administration and Management. And so what he did is he brought us into the fold of the trial court. We worked for the judiciary. We're in the budget for the trial court. So they just sort of moved us across and started giving us other things to do. And that began primarily, really in earnest in 2003 when this idea of metrics started to gain traction. Now, in 2003, Chief Justice Marshall assembled the Visiting Committee on Court Management when they came into the trial court to examine how the court could become more efficient and justice could, become more expeditious. And so several months later, the Monin report was released. It was named after the Chancellor of Boston College, Father Monin. And it came out with its major finding, or at least the finding that it's always credited with, is that the trial courts needed to create a culture of high performance and accountability. And that's what it needed. It didn't take issue with the quality of justice, but it did take issue with how that justice was happening. Following the report, the legislature then created the Court Management Advisory Board, industry leaders that were there to consult with the trial court and help them, come up with solutions and examine their practices. So as one of the first things the trial court did in 2004, it created time standards for each case type, how long it should take a case to be disposed of. So sort of a target. In 2005, it adopted the National Center for State Courts 4 case flow metrics, which were clearance rate, time to disposition, percentage of cases pending beyond the time standards, and trial date certainty. A couple years later, they also adopted Access and Fairness, which was another court tool, and that was a survey of court users to see whether they thought they had adequate access to justice and whether or not they felt it was fair. So when the metrics enterprise first started, around 2003, we were just piloting mass courts in the Boston Municipal Court. Up until this point, every court had its own case management system. Makes collecting data very hard. And it's all measured in different ways. And so we needed to bring that together. So in 2003, they started a pilot in the Boston Municipal Court. In, I think, later 2003, the Land Court adopted a web-based mass court system called Mass Courts Lite. And then in 2006, marked the beginning of widespread adoption of mass courts to all of the other departments. Now, at that time, there's a good amount of data. There was data starting to be collected in mass courts, but it wasn't across all of the system. But the leadership, and that there was an advisory board for a working group for metrics that said, let's not let the perfect be the enemy of the good. Let's start reporting numbers now. And as we continue to report the numbers and the data collection and data recording will get better and better as we go along. And that is what happened. So in 2006, they released their first metrics report. In 2007 through 2009, they released their first Access and Fairness report, survey of the court users. They repeated that again in 2017, 2023, and I believe we're looking to do another one next year. And throughout all of this time, those caseflow metrics reports were being compiled and released. And as each year went by, the data got better and better and better, and it got more electronic. Up until this point, the different departments were printing out spreadsheets or would send us a Word document with the list of numbers in it, and we would have to enter them into a spreadsheet. So data collection was a challenge. But now with mass courts growing in use, it was allowing us to gather the data centrally in one spot in our department, which at this time was still the staff of the Massachusetts Sentencing Commission. In 2013, though, with our first court administrator, Harry Spence, he decided that that was no longer a proper name for a unit that was going to be charged with conducting research for the trial court. So he changed us to the Department of Research and Planning, or DREP. And so that is our name. If you hear DREP, they're speaking of us. Our mission at the time was to enable and support data-driven decision-making within the trial court through data analysis, statistical reporting, and other research activities. I would add planning to that. There's some of this is into planning, but planning and operations have become major, major domains that we've been working in. So by this time, we're getting into the mid-2013s. The data is becoming more electronic. It's really helping to have it that way. We're taking the burden off court departments to compile this data, and we were compiling it for them, which was really great. And then in 2016, we acquired Tableau, which is, if you're not familiar with it, it's a platform for data dashboards and compiling data and life. There's a couple people from DREP in here. Our life changed entirely. It made things completely different. And I hope it also helped our partner here, Steve Duncan, and our JIS D department at the time, because what it allowed is we didn't have to ask for extracts of data anymore. We didn't have to send an email saying, hey, can you give me all filings from this period of time? They created a data mart for us. They created a download of data, which was just fantastic. And it was, it really pushed us along and allowed us to do a lot of work without causing much much more work for anyone else. So just to give you a quick, I know I'm running out of time, so I just want to give you a very quick idea of what we've got now. So we now have a very significant platform in the trial courts, tracking data, providing dashboards about case management, interpreter services, court service centers, every area that touches upon access to justice. And to give you an idea, we have of our folders or our projects that we've done in Tableau in the past year. To date, we've had over 53,000 views from within inside the trial court going to those dashboards. We have 29 public dashboards and have over 79,000 views of our public dashboards. And of course, we do much more than just putting data into dashboards. We also respond and do data analysis for our executive office, for our the various court departments, for our OCM partners. We do surveys, we do research reports, and we partner with all sorts of external partners like the National Center and others in the universities to collect data and share data on these important areas of access to justice. And so now we hope that the research can now really help support this area and make other people's policy makers' job easier and allow us to gauge the success and the need for and any needs that still exist. Thank you.
The court's very lucky to have Lee. I really appreciate her friendship and support of. As somebody coming into the court just over the last few years, I've been very lucky to have her help. I don't know if she's nice to me only because she calls asking for more memory and more storage space every year, but she's fantastic. So, Lee, has brought you up to the point, I think, of you start thinking about the pandemic and the impact of the pandemic on the court. Long before I got here, Chief Budd, Chief Green, and Chief Kerry had saw the need for technology really to improve access to justice. And so I think around 2017 or 2018, they really had started the process of looking at what was needed technology-wise and to start to pursue a bond bill. And then the pandemic got in a little of the way of that. And I came in the middle of the pandemic in about 2021. All the courts were closed. And I can remember coming in, there'd only be a few people, from the courts in the office. And those first couple months were pretty good. Everybody was working from home on Zoom. And then all of a sudden, everybody wanted to come back to the courthouse and continue to use Zoom. And we'd have 2 or 3 people use Zoom, and that would take down the whole courthouse. So, every morning I would start the morning by hitting refresh on the browser, hoping that the network would stay up. But I think it taught us that we had a lot of work to do on infrastructure. And we've spent a lot of time doing that work over the last few years, basically rebuilding networks inside of 102 court locations. Now on a daily basis, for the court folks that are here, I think there's real stability in both FTR and in Zoom. There's a lot of confidence in using Zoom now for virtual events that wasn't there a couple of years ago. You couldn't depend on the network being up in order to do that. And so it always sounds good that we really focused on the network and the infrastructure, as well as mass courts becoming an application that the court departments could actually fully use digitally, because we're still not there yet. That sounds easy and a good thing to do, but I think for our folks that are from the court, it's incredibly disruptive. Stuff breaks. We're changing a lot of things at the same time. It's very painful at different times, and it requires a lot of support from the departments to allow us to keep moving forward. And more disruptive sometimes than others. But the guidance, they keep moving forward, and we're doing that as quickly as we can. And the benefits we get from that infrastructure investment and improvements, I think about the Wi-Fi that we've now done in 91 of the 94 courthouses. We're seeing more than 40,000 people a month using the Wi-Fi. I think we've heard a couple different folks refer to the lifeline that phone is. Well, there was no cellular penetration in courthouses. Once you were in there as a self-represented litigant, you were on your own. You couldn't reach out and get support. You couldn't reach out and get access to different documents. You were really inside the courthouse and locked in. And we're seeing an incredible amount of usage of Wi-Fi now. And I think we've talked about, some of the challenges out west, getting attorneys to take on pro bono cases because they'd have to go sit in the courthouse and be down for the whole day, not sure when they were going to get called, and not have access to do any work. It's been a critical component in making attorneys more available, especially in the western part of the state. Now, the CIO probably made a terrible decision starting from the west with Wi-Fi and coming east, because we haven't done the John Adams Courthouse yet. That may be a career limiting decision. I'll let you know at a different time. Lee mentioned signage. We're super excited. We put in a digital signage solution in Chelsea. We spent a lot of time. We took a lot of feedback from Professor Karras and others to design a solution that wasn't just a TV hanging on the screen, but the infrastructure to actually develop the content, understanding what people needed. We have it ready to go. We're pursuing funding to do that across the other 93 locations. We're very excited to get it out. We know entering the courthouse can be a very anxious time for folks coming over from higher ed to work at the judiciary. I could not figure out where in the courthouse I was supposed to go. So I could imagine coming in on a day that's that important to you, how important better signage, support and multilingual, can be. We're also putting a lot of effort into our website, trying to think about it from the perspective of the users as opposed to the court just publishing information to folks, thinking about plain language, accessibility, the forms that we're putting out there that are complicated and not easy to follow. The juvenile court spent a lot of time thinking about trying to document the processes so people could better understand how to do that. And I'm not going to steal all the thunder because Caitlin Reddy, who actually does all the work in IT, will be in the second panel and talk about things going forward. But we're very excited about the partnership that we have with Suffolk right now in Guide and File, and really simplifying the process to, fill out forms and enter the services of the court. Everything starts with a form in some way. There's been a lot of work done on some of our high usage forms to really simplify it and make it more like TurboTax, where you walk through and anybody can fill it out. And so, I think, access to justice is not a one-time project. It's going to be continuous improvement over time. The impact of AI, we're very excited about things that we see, about the possibilities that brings, when the right time to bring that into the court, I think we're still looking at. And I think we understand our job is to make the front door to justice as open and easy to navigate as possible. And I'm confident that technology and the way that the court uses it will make a big impact on that.
Thank you, Steve. Next up is Brian Reichart. He's the director of the Massachusetts Legal Websites Project at the Mass Law Reform Institute. In this role, he leads technology initiatives that expand access to justice across Massachusetts and supports legal aid attorneys in leveraging technology to strengthen their advocacy. Before joining MLRI, Brian served as a clinical instructor and practiced as an associate at a global law firm. He is also a member of the Supreme Judicial Court Standing Committee on Pro Bono Legal Services. Thank you.
Good afternoon, everybody. I want to start with just the most important message of the day is just thank you. So thank you all for being here, for devoting your time to this issue, but also very specifically, thank you to the many people who have contributed to the success of the Websites Project over the years. That goes for the last 8 years that I've been a part of it, and I know I've worked with many of you, but also beyond. The Websites Project has been around for over 20 years, as many of you know. We rely on funders like MLAC, the Boston Bar Foundation, the Mass Bar Foundation. We rely on editors and contributors from legal aid organizations, including my organization, the Mass Law Reform Institute, but legal aid organizations across the state, volunteers who make our site a success, and our staff at the Websites Project. So this, it felt funny to talk about the accomplishments and the growth of the Websites Project, one, because I haven't been here in 2005, but also, our success is really working in collaboration with the courts, with our friends at Suffolk, and so many others. So thank you. For those of you who do not know about the Websites Project, our purpose, broadly stated, is to increase access to justice through the innovative, thoughtful use of technology. And we do this by providing legal information and referrals to low-income Massachusetts residents, to support legal aid advocates and pro bono attorneys that help people with their civil legal needs, and playing an active role in access to justice-related initiatives, including those related to pro se litigants and the civil legal aid ecosystem. So as our name suggests, the primary way we do this is through websites. So back in 2005, when the Access to Justice Commission was formed, we actually did already have 2 websites up: Mass Legal Help, a website that provides legal information to the general public, and Mass Legal Services, an innovation hub for the legal aid community and those who provide civil legal services to low-income people. Those sites have grown tremendously in the last 20 years, as you can imagine. Who could have thought back in 2005 that today, 2/3 of users of Mass Legal Help access the site on their phone? And that has implications to how we think about content and how to deliver that content. It needs to be easy to read and understand on your phone. Mass Legal Services, we're embedded in the legal aid community, and as a result, we can respond very quickly to the needs of the legal aid community. I can think, for example, just in the last 11 months or so, we very quickly mobilized the creation of workspaces and email groups in response to the needs of immigration advocates in Massachusetts on a range of issues. And then, of course, there are sites that did not exist back in 2005. So the Massachusetts Legal Resource Finder, which the commission video referred to, in 2005, there was a form of a directory, but it was a simple put in your zip code and you get organizations that may be able to help you. Today, thanks through the support of a lot of individuals, including Gordon and our friends at Suffolk and others, the Legal Resource Finder is a much more robust site where folks can conduct a guided interview, put in their income, their location, their legal need. They can even type up what their legal need is through the use of Spot, an initiative at the Suffolk Lit Lab, and get access, find out what are the organizations that have open intake that can support them in their location based on their income and based on their need. Another site that didn't exist in 2005 is massprobono.org. Now, I wasn't around here in 2005, but my understanding is the Mass Bar Association had a book that was a pro bono guide. And in around 2012 or so, the Volunteer Lawyers Project, another one of our wonderful partners, and with the support of others, started managing massprobono.org. The Websites Project took that over 2 years ago. We recently relaunched it in February of this year, and have been very, very encouraged by the results with 500 connections made between volunteer lawyers and legal services programs just in the first 6 months of its use. Mass Legal Answers Online actually started almost 9 years ago to this very day in 2016, and that is the Massachusetts home of the ABA's nationwide Free Legal Answers program. So this is a site where individuals can post civil legal questions and volunteer lawyers answer them through that site. And we answer about 150 questions every month on a range of civil legal issues. And we have a volunteer pool of about 600 pro bono attorneys here in Massachusetts. I know we're running behind schedule, but just a few thoughts on looking forward. I know there's a panel on looking forward, but for us, it's continuing to try to meet people where they are. And I know that's a phrase that's used a whole lot, but I think about that very specifically in terms of what is the information that they need? How do we deliver that information? So that goes for the language we used, which language we used, the vocabulary we use, and then what are the means that they're accessing that information? I referred to phones. Are they using Alexa, for example? Are they using artificial intelligence? We really have to be aware of that. Are they using older school technologies like going to the library and asking for help? We also have to be aware of that, meeting people where they are. Advertising not only on social media as we do, but also on billboards as we also do. So we really need to be mindful of that throughout all our work, and we have been for the last 20 years, but we need to continue to do so in the years ahead. Another thing is continuing to be a source of trusted content. Now more than ever, there's all sorts of content on the internet. We benefit, as I said at the very beginning, from being collaborators with the legal experts here in Massachusetts, many of whom are in this room and watching online. And we hope to continue to provide leadership in thoughtfully using technology. And also, we're very mindful of the fact that we need to support others in this space. The Access to Justice Commission correctly often refers to the continuum of services to close the justice gap, and we're just one piece of that. And we hope the Websites Project can continue to be not only a way to address that, but also support the many of you who do. So thank you so much, and thanks a lot.
So we're running a little bit behind, but I think we have time for opening it up for discussion. I just have one question for our panelists, which has to do with digital equity. Technology must address barriers such as language, digital literacy, limited internet access to avoid reinforcing existing disparities. but I'm interested in hearing what our panelists see as potential avenues or solutions or things that maybe have been implemented today. I know we're talking about the future later this afternoon, but if you could address the digital equity issue, if you don't mind.
I'd certainly say there's a lot being done around accessibility as one item there. And I think Cherise Perry will be here later if she's not here.
She's over there.
Cherise, who will talk about some of the work that she's done, especially geographically, to make access to technology easier.
So we have 1,000 pieces of content on Mass Legal Help. Every single one of them just about has a button that says, I think, read to speak, where you will hear the audio of that article. Our information is professionally translated in Spanish, and much of the content is available in other languages. And then we solicit feedback. So Mass Legal Help was recently relaunched last year, and there was a host of user testing, not only from legal experts and advocates, but also from the community. And so we made all sorts of changes based on that. And then also last year, the entire website's project staff took a class on accessibility standards, and we incorporate that into all of our work.
I was going to say that the trial court, I believe, is working on accessibility now, and we get notices from them that they would like us to make some of our content more accessible, and that they have some tools that they will be using to make them more accessible. And so I think that's great. I mean, we were just talking about this last week. Some of our content is very hard to make accessible, but we're willing to and looking forward to different ways, whether it's text to speech and other, writing descriptions of our charts instead of other being able to view them. I think that technology should be getting better as well as we move forward. So hopefully that will be helpful to us.
Okay, well, thank you for that. And I think we need to move on, but thank you for your comments and your remarks and for addressing the digital equity issue, which I expect will come up in our second panel this afternoon.
All right, thank you so much to that first panel. And now we are to the part of the program featuring the Access to Justice Fellows. We're so glad to have this combined program with all of you. And today we officially mark the 14th year of the Access to Justice Fellows, and we have 17 new fellows here. The Fellows Program is a treasured part of the Access to Justice Commission. We're pleased to continue this partnership and support the Fellows' ongoing work. Pro bono efforts like this have a huge ripple effect. They really do. And they're changing lives and communities all across the Commonwealth and beyond. The program started only in 2012, and since then it's had 230 retired attorneys and retired judges who have provided more than 300,000 hours of pro bono service to 101 partner organizations. So people not only do this work while they're in the fellowship program, but they found out that 80% go on to do more than a year of their fellowship work, which is really impressive. None of this would have been possible without the team behind it. It was co-founders Sue Finnegan and Martha Koster who took this great idea and ran with it. We thank the SJC for its enthusiasm, especially the staunch support of the late Chief Justice Gantz, the Lawyers Clearinghouse for managing the program since 2014, and Mintz as the firm sponsor of this Fellows program. So it's a particular pleasure this year to welcome people because I know and personally admire so many of them. I think there are 5 of my former colleagues from the trial court among them, and all of these organizations are just so lucky to be getting these wonderful, wonderful fellows. Over the years, Access to Justice Fellows have helped nonprofits, service organizations, and the courts. They take the most experienced people in the area and they get them to volunteer and put them to work on things like fighting on behalf of wrongfully convicted people, tackling the ongoing housing crisis, defending the rights of children and immigrants and the needs of veterans, advocating for medical and environmental justice, and so much more. So the program really is a striking reminder of collective service and how much we can all do when people work together. We're so excited at the Commission to see what the whole year has in store for all of these great organizations and their fellows. So all of you will continue to change the world for the better, just as you have for all of your professional careers. And so with that, my co-chair is going to read out the names, and I believe she'll read out the names and the organizations.
I will do just that. And when I call your name, I'll ask you to stand. I know that not all of our fellows could be here in person today. Some are watching online and some are probably doing their good work already. But here we go. Roger Bertling, who will be working with Greater Boston Legal Services at the Consumer Rights Unit. The Honorable Pamela Dashiell. Judge Dashiell will be working with Volunteer Lawyers Project in the Appeals Clinic. Kevin Finnegan with Volunteer Lawyers Project, the Family Law Clinic. The Honorable Linda Giles. Judge Giles will be working with Greater Boston Legal Services and Litigation Mentoring. Jane Goldstein will be working with the Women's Lunch Place. The Honorable Karen Goodwin. Judge Goodwin will be working with the New England Innocence Project. Brenda Kronberg will be working with the Massachusetts Court Service Centers. You'll be hearing more about them. Diana Lloyd will be working with the Anti-Defamation League. Lizelle Masenka will be working with Project Citizenship. Ellen Messing with Lawyers for Civil Rights. Jonathan Mishara with Conservation Law Foundation. The Honorable Maureen Monks, Judge Monks, will be working with SERVE, which is Settlement and Early Resolution Volunteers. Mary Murray will be with De Novo in the Immigration Unit. George Mikulak will be working with the Barbara McDowell Social Justice Center. Florence Pagano will be working with Mass Law Reform Institute with the Habeas Project of Massachusetts. And Susan Sheldon will be with De Novo in the Immigration Unit. And the Honorable Robert Ullman, Judge Ullman, will be with the Political Asylum Immigration Representation Project, known to us as PAIR. So please join me in congratulating all of our fellows. You are our Access to Justice warriors, and I will ask that all of the fellows who are here, please stick around at the end of the program so we can get a photo of you. But now, we're going to take a short break. Try to quiet this room. Everyone is having entirely too much fun. I think that's probably a good sign, and hopefully we have sparked some food for thought. But I want to make sure that we have time for our esteemed second panel. And I'm going to begin by introducing our moderator, because she's not a commissioner, although she is a great supporter of our work. So, Professor Diane O'Leary is a professor of legal writing, and she is the director of Suffolk University Law School's Legal Innovation and Technology Center, AKA the LIT Center, and the LIT concentration, which is nationally recognized for leadership in legal technology. She's the author of a practical skills guide for the modern lawyer, which is the first student-centered course book on legal innovation and technology. And I think that focus on the student-centered piece is important. I know we're going to be talking about user-centered focus as part of what we do going forward. Professor O'Leary focuses on technology competence in legal practice, so I probably should take your course. Generative AI, research tools, document automation, and cybersecurity. She designed and teaches Suffolk Law's first courses on generative AI and modern legal practice technology. She's got lots of awards and honors, and in the interest of time, I'm just going to cut to the chase and ask you to join me in welcoming her to the podium.
Good afternoon, and yes, the biggest honor is to be here with all of you, so I'm happy to skip those backup remarks. Thank you, Lisa. It's a pleasure to be here. I talk to law students every chance I get about the words access to justice, But in the insulated classroom, those are just 3 random words, frankly, and it's hard to make them actually come to life for students. So it's great to be here when they actually mean something, and all of you are walking the walk and talking the talk and actually making those words do something for real people. We joke in law school that the best part of academia is getting to talk about really tough, interesting things and then go home and not really get to or have to do anything about them. But again, Suffolk's mission is to do more and be in the conversation and try to collaborate. So it's my honor to represent the law school across the street. It's an honor to learn from all of you and our panelists. And it's also an honor to help our students be inspired to continue this important work. So with that, I will shut up. It is a privilege to turn it over to our panelists. As you have heard, our goal is to look to the future, and we will try to do that. In the spirit of innovation, we will try to do it a little bit different. Each panelist in a bit of a rapid fire fashion, if you will, and I'm gonna keep us to the clock, is gonna start with about 5 minutes of kickoff remarks. From there, we're gonna have some Q&A so we can hopefully have time and space to talk about some of the most pressing themes today. And most importantly, as we build this work into the next 20 years, what we need to be thinking about. With that, let's get started. You have the bios in your materials, so we'll be brief, but it's a pleasure to first introduce Charisse Perry, who I'm pretty sure many of you in this room already know, as do I. Charisse is the Director of Court Services and Law Libraries for the Massachusetts Trial Court's Office of Court Management. She provides statewide oversight of the court service centers and the law libraries, and she spearheaded the rollout of all those newly developed court service centers. Prior to that, she developed and managed the Boston Court Service Center, was in private practice, and a staff attorney as well, and currently serves as a commissioner. So with that, she's also a graduate of the lovely Suffolk Law School. I'll turn it over to Charisse to get us started.
Good afternoon, everyone, and thank you for the introduction. Of course, thank you for being here. If you know me, access to justice and self-represented litigants have been a passion of mine since law school, and I have not wavered from that. You've heard from a lot of people from the trial court today, and you'll hear from more of us, but I think we always think we know where access to justice sits within our institution. So I'm just gonna do a quick overview of where we are within our institution. We have our illustrious SJC, Appeals Court, Jury Commission, Probation, and then we have the Trial Court. Within the Executive Office of the Trial Court, which is led by Chief Justice Brieger, we have our 7 court departments. Many of those are represented here today. And then we have our Office of Court Management, led by Court Administrator Thomas Ambrosino. Within that, we've already seen Steve Duncan from JISD IT. You'll hear from Caitlin Reddy, who's part of that department. We've talked with Lee Kavanaugh, who's the head of DRAP, as she mentioned, legal department, fiscal, court education, facilities, security, HR, Office of Workforce Rights and Compliance, and then the lovely department led by our chief, Dr. Natasha Scruggs, which is the Office of Access, Diversity, and Fairness. You will find DEI. You will find language access, court records and transcripts. You will find alternative dispute resolution and our A2J department. And then you will find my department, which I will speak about. I have been with the trial court since 2014, and I oversee the court service centers and law libraries. So I have the pleasure of working with 100 access to justice warriors that are committed day in and day out to serve the public, to serve the bar, to serve the bench as well. Our law libraries, I think, we're kind of been around for 200 plus years, and we're really the people that started access to justice. We're on the forefront, and I think as knowledge engineers are really gonna be instrumental in how we leverage and we look at AI and technology and building out systems, right? What do we do? Reference questions, chat, research, legal research, and reference for every one of those people. We also provide document delivery to our incarcerated populations and many of those people that need access to those services. When the pandemic came, we weren't fazed by that. Why? Because the law librarians were doing technology. We were doing email, phone, and our lovely human chatbot system of our instant messenger, where you can ask a law librarian a question 9 to 4, Monday through Friday, and they will answer your questions and give you everything it is that you need. I think the one other part of what the law librarians do is our Law About page. We just went live on an AI page that has laws from not only here in Massachusetts, but across the nation. So if you haven't seen our Law About pages, please, please, please Google trial court law libraries and find all of the information. I think what's valuable about the law libraries is we do and provide the service free of charge. So whether you're a solo practitioner, if you're a person in legal aid and you just need assistance, you're having difficulty with a case, please reach out to the law libraries. Last but not least is the court service centers, which you've heard a lot about. Chief Justice Gantz was a huge advocate for the court service centers. Much of why I am here and much is why I pushed the envelope on that is because of him. We have 8 brick and mortar court service centers. We have 1 virtual court service center. We have 3 circuit operations, and we have 2 more court service centers coming down the line in Framingham and Quincy, probably within the next 5 years. We are located not everywhere, but we are everywhere because Zoom makes us available everywhere and outside of Massachusetts and outside of the country. But people have services and they need services in Massachusetts court cases, so that's what we do. Computers, language access, one-on-one assistance with forms, demystify the court system, answer questions, prevent people from having to come down to the courthouse to file for divorce if they don't have their marriage certificate. So we really embrace the idea of meeting people where they are. We look at all of our platforms. We look at all of the ways in which we can provide assistance. And technology is important. We love it. It has made our operations super duper efficient. Steve Duncan knows we love it. We are on the phone with him always about what we can do, but we also recognize that there's an entire population that technology is not going to work for. And I think for us, it's always making and reminding people that technology can only get people so far, but we have to be mindful of that population that technology is just not going to work for. And let's not forget about them. So I think that's my rapid spiel. Thank you very much.
Thank you, Charisse. Good modeling for our plan. Next, it's a pleasure to introduce Emily Dinas. Emily, earlier this year in April, assumed the role of the statewide Manager of Justice Initiatives in the Office of Access to Justice and Court User Experience. So she is our court user expert today, where she leads efforts to promote equity, streamline form creation, and enhance that overall court user experience. And she does that with over 2 decades of experience at the trial court, primarily within probate and family, thinking about, again, operations, user-centered delivery of the court services. Emily.
Good afternoon, everybody. So I'm going to cut some things off my speech in the trying to get this down because Charisse was so quick. So I am fairly new to this position. I started in April of 2025, but like Diane mentioned, I am career trial court. That gives me a unique perspective in some ways. Okay, now I'm going to talk about forms. Oh, thanks, Charisse. Thank you. So the Office of Access to Justice and Court User Experience is a new department. It began in August of 2024. We are focused on court user experience, amplifying resources, enhancing accessibility, but my role is really improving forms and self-help materials. So I'm going to talk about forms, which I know is everybody's favorite topic, if I'm going by the emails that I get on a weekly basis. So I've had the privilege of spending 20 years in the trial court, seeing how innovative it became, how much it's changed over time, how much the Access to Justice Commission has guided the work that we do. I had the luxury of working for Chief Justice Paula Carey not once, but twice, and I rely on her experience a lot in this new role. When Chief Justice Carey was first appointed the chief of the Probate and Family Court in 2007, she not only came in with limitless energy, but also with the idea that we have to digitize all of our forms. Day one, she was like, let's get paper online. She tasked me with that. So at the time, we really created versions for attorneys because that's what we were hearing about. We were hearing from attorneys saying, put all your forms up online so they can be fillable. We didn't really think about plain language. We didn't think about self-represented litigants as much at the time. We were just sort of batch putting things up. But we were innovators at that time. We were one of a handful of state courts that even had fillable forms online available. I remember calling New Hampshire and finding out what they were doing. It was a very small group of us at that time. Online, easy-to-use, fillable forms are now the trial court norm. There's no new legislation that comes out that doesn't require us to create these very accessible online forms. I created the first Calculating Child Support Guidelines worksheet. It was back in 2007, and we still use that format today. And that was really where I saw the court change towards, okay, let's make things available for self-represented litigants. Let's do technology tools. Let's create things that can be used by people other than attorneys. In 2023, retired Chief Justice Locke and Court Administrator Ambrosino rolled out the Order on Forms Management. That required that all new and revised forms from any department needed to be in plain language and needed to comply with a design guide. This is my slide on that. So since 2023, we've created and revised 215 forms, which is about 35% of the forms available on mass.gov. Obviously, we have work to do, but we are continuing to move in that direction. This really reframed how the trial court views forms and self-help materials. So a form really isn't just a piece of paper, obviously. It's a path to getting in front of a judge, to receiving services, to communicating with the court, and receiving important communication from the court. They drive procedure. They standardize practice and simplify processes. They help court staff and court users understand complex legal issues. And they also show cracks in statutes where they didn't anticipate issues. So when you draft a form, a lot of times it's, oh wait, they didn't think about that when they drafted it. How are we going to now work around that? They're important and we want to get them right. We talk a lot about balance in forms development. So we're always balancing court users and what information the court needs. We're always balancing plain language and legal information and what's required to be on a form. So you'll hear me, coming from the court perspective, talk a lot about thinking about balance and how we walk that tightrope. I personally often ask myself, what have I done to help someone today? Because I know that our court staff and our judges and our probation staff and our court service center staff and our law librarians and all of the court people, they help hundreds of people a day. So I see my role as helping them help people. How can we use technology to get the users who can use a guided interview or an online form or an e-filing system away from the court so that they can help the neediest people? How can we use language access online? Language access online to help people understand a process in their language where they don't have to go to the courthouse to help with the filing of a form. So I want to thank the Access to Justice Commission, who has partnered with our office. And I look forward to, I put the word sparring with the other panelists, but actually I'm going to change that to passionately agreeing with the other panelists. So thank you. I hope that was under 5.
Dare I suggest we put the sparring back in? Next, I have the pleasure of introducing my colleague, Quentin Steenhouse, who's an adjunct professor and co-director of the Suffolk Law Lit Lab, which is the actual building place at Suffolk that actually creates tools and partners with others. He's also the founder and CEO of Lemma Legal Consulting. So his work focuses on just that, building real things that people can use to get real help with the system. And his work has been featured in national media, the ABA Journal, the New York Times, recognized by the White House, and all the things. So with that, I'll turn it over to Quentin.
Thank you so much. And I just have a couple of slides here to help me remember what I was going to say. Thanks for that introduction. I'll just say, I grew up surrounded by woods and cornfields. So it's really interesting that I became so focused on using technology to help people get access to justice. And I think it's important to remember those folks who are left behind. So I spent the first 12 years of my career at Greater Boston Legal Services as a frontline attorney, helping people with housing challenges, and I discovered tech as one way to help solve those challenges. I started at Suffolk in the Lit Lab in 2020, and I see many of you here in this room, actually, who helped join a call to action that was put forward by then Chief Justice Gantz, who's passed away, who said, hey, we need to respond to this moment during the pandemic when people can't access things any way other than with technology. And I think we did that. We succeeded in building something really great. So in our lab at Suffolk, our students learn how to build tools that help people solve legal problems on their own, from a smartphone, from a website. Often, it isn't completely on their own, but they have somebody who's a helper, like somebody in the court service center, an advocate who might be at a place like Rosie's Place, someone who is going to be able to help guide the unsophisticated user to use the technology to help solve their problem. But we try to design the technology to be as easy to use, as accessible as we can. So they're learning things like plain language. They're learning things about design and user experience to simplify the task of the person using these tools. The tools that we build are really kind of one of the first forms of what we call legal AI. They're all rules-based systems for the most part that just are a flowchart, essentially, you could follow through from start to finish. You know exactly what you're going to get at the end when you put something in at the beginning. And I think there's a lot of life left in these older technologies, especially when we're using them to help people who are themselves the helpers. More and more, we are finding the safe ways for us to apply generative AI to help make these tools even easier, even better, even more capable, without taking away the safety and predictability. And we do that by doing things like finding the tasks that really are safe. Things like, I'll put a couple of examples here. You can see on about half of the examples on the slide here are those older systems that just are 100% predictable. And a couple of them are starting to use AI in these new safe ways that we think are going to represent the future. Things that take information out of data forms that somebody has, so they don't have to retype information. Not a very good use of someone's time to type information that already is on a form that they have with them. Someone can point to smartphone, add a document, and pull out the names of the parties, all the key facts that they might need to put into a court form. The other thing that we're doing is using AI to help people get to the right resources. So I'm working in Oregon with the state bar there, and we're helping the residents of that state get connected to a lawyer through the lawyer referral service using AI. And the AI there is being used to ask questions of the person who's trying to get a lawyer. And then it's using that information to help match them to the right attorney. And we know these tools can be safe because we test them. I think that's something else that's really important for us to think about in this new world of generative AI. We can't release solutions into the world without testing them to make sure that they actually work, that they actually solve the problem that we're trying to. We test them for accuracy and safety in all of these ways. I believe I'm going to be leading Caitlin Reddy, so I just want to talk a little bit about a project that I think is also representing the future of technology integration with the court and access to justice. So we spent the last year working together in a very short time frame on building one of our first electronically filed court forms. It's a guided interview that goes from start to finish of helping somebody fill in the document correctly. And then it actually can also be e-filed through our partnership with Tyler Technologies. We're the first third-party certified nonprofit e-filer in the country. And thanks to the trial court here for letting us work together and use this technology right here in Massachusetts. So we're going to hear more about that soon, I think, and that's where I'm going to stop.
Okay, thank you, Quentin. Yes, finally, we'll turn it over to Caitlin Reddy. Caitlin's a legal and technology professional with about a decade or so of experience driving digital transformation in the public sector. She is currently Deputy CIO for eCourts for the trial court, where she leads initiatives to modernize operation across all the trial court departments. and previously was with the Boston Municipal Courts and the eCourts team, again, thinking about user-centric approaches, adoption, and data-driven decision-making, another theme we'll turn to after. So welcome, Caitlin.
Thanks, Diane. Hi, everyone. So I'm really excited to speak a little bit about the eCourts team and what we do here at the Massachusetts Trial Court. And you can see that goal up there is pretty wordy, but really at its core, our mission is to make the trial court more modern and more digital. And we do this through strategically applying technology and standardized processes to make court operations more effective. Technology alone, though, is not enough. And I think if we approached this goal simply by prescribing the technology that we in IT think would get the courts closer to modernization and digitization, we wouldn't be very successful. We're successful when we collaborate with our departments, when we get the right people in the room to gather requirements about technological solutions and to make decisions about technology that will impact the courts. And we do that in eCourts through the use of our eCourts business analysts. A few of those folks are in the room with us today. And really what they do is represent the needs of each of the 7 trial court departments when we make decisions in IT about technology. This collaboration allows us to understand what each department needs, wants, what their goals are, and what their workflows look like. And that allows us to deliver solutions that really support and improve the day-to-day work that's being done on the ground in the trial court. It makes the work that we do faster and more efficient, and it also then trickles down, and it allows better access for everyone who interfaces with the court and creates a better experience for those individuals. On the screen here, you can see a little bit about our approach. I'll hit through each of these and touch on a few of the projects that kind of go along with each of these areas. So we first start with planning. We create action plans and strategies that move the court towards its goal of becoming more modern and more digital. We also optimized how we capture information so that we can reduce manual data entry and manage the information that we have more effectively. We also develop processes and tools that allow us to accept information electronically, particularly electronic case filing. This makes everything faster, more consistent, and easier for folks involved in the process, both externals and internals. We offer e-filing in all 7 of our trial court departments. Most recently, we launched that service in the juvenile court. And what we know about e-filing is that when we offer it, people take advantage of it. Of case types that are set up to be filed electronically, 70%, or now this year, even more than 70% of newly filed cases are filed electronically. We also work towards the delivery of information from the court in a digital means. So we recognize that many folks in our community have come to expect information that comes to their email inbox or their cell phone, not necessarily on paper to their mailbox. We also focus on access by improving the information that we have available electronically through our system of portals, like the Attorney Portal and the masscourts.org public portal. And finally, perhaps my favorite, and what you'll hear about a little bit today, is our offering of innovative services. That includes things like the guided interviews that we will talk about a little bit more probably with Suffolk, and also our upcoming online dispute resolution project. And really, none of this work happens in isolation. Any success that we have comes through the collaboration that we have with our departments, with our executive office, with our partners, with our vendors, and of course, with folks like you. So thank you for coming. Thank you for engaging with us. And thank you for providing feedback that helps shape these systems. Really together, we will work towards building a more accessible, a better, and a more modern court for the future. Thanks.
Alrighty, so with that, my job as moderator was to plant a lot of interesting seeds and then sit back down and let our panel discuss, debate, and share some more specifics in response to some of the themes that we'd like to unpack. So I'd like to start, instead of the word we, which we've been hearing all afternoon, let's turn to kind of the them and the users, the public, the experience of the court, whether it's forms or a new ODR process or a guided interview. how are we doing? Is modern form creation or processes, are they working from the user point of view? And most importantly, I would love for our panelists to comment on what we need to do to get better and to ensure that we're able to track, instead of just saying we have all these terrific court forms, figure out if they're actually helping close the gap.
I can start, Diane, if you don't mind. So I look at it two ways. We have both internal feedback and testing and external. So we haven't done a great job of even collecting internal feedback on our forms. So that's something that I'm working on, some internal workflows where we do feedback gathering. I've spoken with Sharice's group, and we want them to be partners because they work with court users every day. So getting external feedback is difficult. It's difficult for every state I've ever talked to. Every single one is trying something. It works, it doesn't work. It's balancing the time it takes to get that feedback and to process it and to make those changes with really like the lack of resources we sometimes have in forms creation. But we have worked with some great partners. I see Dr. Karras here and his Bentley group. They've provided feedback on forms before. We have, in probate and family court, we instituted a 30-day comment period. And that's a public comment period. We release a form for use. People have 30 days. It could be anyone. It could be court staff. It could be court users. It could be bar. It could be anything. To provide comment, and then after 30 days, we compile it, we make changes, we re-release a form, and that form is then final and effective. But it's in use, so that was something that I got from the National Center from State Courts. It was incredibly time-consuming, I will be perfectly honest with you, but I think it got us closer. We've also piloted forms in the court service centers for real court users to look at, is this working? Is this wording not working? Are people misunderstanding the information we're trying to get here? So I'll just probably end. I'm going to probably turn it over to Quentin because I can imagine he's got more to say on it. But what I will say is that we are going to try many different things going forward to get the best product out there. And one of those is external user testing and external user feedback.
It's a lot of really great initiatives there. And the gold standard, I think, is really when you can sit down with a real user, watch them use a form, whether it's a digital tool like WeBuild or a paper form, and then see where they're struggling. We call that usability testing. And I think that's really the thing that we want to encourage and emphasize. It can be as simple as getting a few volunteers and then giving them a $25 gift card to compensate them for their time, because that is something that takes an hour or so of their time, and it's definitely worth it. The thing that we've done is at Suffolk, we've built guides and resources to help people with that court form design process. We've built a tool called ratemypdf.com, kind of a fun name, but essentially—
Which I've used frequently, not to interrupt you.
That's great, I'm glad to hear that. And we've worked with folks in Virginia and the First Circuit, especially, to help them learn how to use that in the court form redesign process. And that kind of gives you just an expert look at the form and gives you some ideas on plain language, things like passive voice use, to help give you some instant suggestions to help make it easier.
Chime in here and also just kind of raise the partnership that we have with Suffolk and really relying on their expertise and their ability to do things like usability testing and how that will shape our guided interviews moving forward. Just a quick show of hands before we start throwing around the term guided interviews. Does everyone know what that means, what that looks like in the context of court? Okay, seeing some head shake. So very briefly, a guided interview is essentially like TurboTax for court forms. When you file your taxes using a tax preparation software, you are not actually filling out the documents that will be filed with the IRS. You're answering questions that fill that out for you. That's essentially what a guided interview is. And I think, we heard Emily speak a little bit about some of the requirements on forms being, cites to statutes, various legal terms, things that are not particularly user-friendly or even really able to be distilled down into plain language, but they're required to be on the form by the statute. And a guided interview is a great way to bridge that gap because the user never sees that information and doesn't see that language until the very end, once they've answered all the questions and the form has been populated for them through this series of plain language questions and answers. So even though that might be sort of technology of today and not necessarily the future, it's incredibly helpful for litigants, and even more so when it can be directly e-filed with the court. So there's no process of downloading and uploading and logging in again. Again, it all runs through one sort of seamless one-stop shop and gets right from the user on a web-based application. So not something they're downloading, something they can access from a library and can file directly with the court. And I think we've seen a lot of success, and we're really excited for the future and all the forms we have to come through guided interviews.
So with that, we're excited about the future, but we all know there's certain challenges or hurdles that we need to think about. So sticking with our users, what do we say to a court user who is worried about things like disclosing their private information, identity theft, security, systems getting hacked, their immigration status being compromised, and all the things we know are real concerns for real people? Are we building that trust and credibility? And if we are, how do we keep doing that? And if we're not, what do we need to do better? Charisse, I'll invite you to tackle that one first.
I think that from a court user perspective, there's a population of them that are willing to take on technology with assistance and training and all of those other things. And then I think to your point, Diane, is that there's also a population of people that have significant concerns with either coming into a court, putting their information into a system. I think a lot of people may come from different countries and environments where technology and computers just wasn't used at all. And there's just not a comfort level at all with actually anything that we do. So I think for us, from a court user perspective, training is extremely important for us to make sure that we can instill that trust. I think our mission in the trial court is, public trust and confidence. And I think when the pandemic came, everyone implemented Zoom, right? Zoom hearings were there, and there was just like this expectation that people could join their Zoom hearing without even knowing how to access Zoom, right? And so we really focus on developing that trust with people, making sure that they're trained on them. So all of these great resources are going to be created, but we have to incorporate training and building in that trust. And I think that on the back end, those folks, and certainly my colleagues here, can talk about how they build that in there. But I think from us, and a perspective from us, is really how do we give and create environments for court users to trust the technology, but then also we have hallucinations and all of those other things. So there's always a concern for us in the use of technology, and what does that actually mean?
Sort of chiming in on that, I think from an IT perspective, perhaps being more transparent and providing information about what we're doing on the trial court side to ensure that our systems are safe. Really making sure that we're up to date and that the systems that we're using are secure, and any system that interfaces with our system is also secure. So we do that, but maybe making sure that everyone knows that we do that in the steps that we take internally to ensure information security. Also kind of thinking to the future, particularly about personally identifying information, or PII, trying to make resources available that are plain language, that are easy to use, that really clearly show what parts of the documents that you file with the court are public and we have to make publicly available. And whose responsibility is that to conceal that information or to redact that information? So I think that that's one thing that we could possibly improve upon in the future, probably working together, Emily and Charisse, to really make sure that folks understand, and then we can build that trust just based on that level of transparency and understanding.
I want to hit on that also, education to the public, but also training and education for court staff so that they understand that the document that they're scanning, to to be able to identify any red flags. If someone's, self-represented litigants don't know they're required to redact PII information. The court needs that information sometimes when it comes to the court. So at what point are they redacting it? But I think really training court staff and making them aware about when they're accessing our case management system, what are they doing and what are they putting out there? I think that's an important piece of that.
I'll just say, like, something for the systems that we're building where we have the luxury of just being the integrator, we try to not hold on to any PII, like don't collect it, you don't have to worry about the release in the same way. And we also just go through regular security scanning. So that's part of our commitment with our partnership with Tyler, is we have to do those third-party audits, and we do those. And we use the same kind of technology that is now very ubiquitous, like that, your bank, you go to a website, it has the security lock. That's just kind of the baseline that I think everyone now understands in a way they didn't.
So my next question was about AI, and in the spirit of let's keep the human first, I'm going to skip that question and stay with our thread of kind of trust and dare I say, the humanity of the system. We had some notes from a representative at Rosie's Place who reported that she always hears the community members there say they need a human to listen to their questions the way they're thinking about them, not the way they might appear on a form. So do we agree that the human element is still really important here? And I presume we do. So if it is, where does the tech stop and the human start? And how do we assess if that's actually happening for our users? So kind of the human-centered design. I'll invite our panelists to tackle that dicey topic.
I work with humans, and so do my staff. So I always looked at services and kind of really put people in like 3 buckets, right? I think that there is the population of people that with assistance, like these tools and things like that, they can go on the computer, they can access them, they can complete the information, and they, in essence, are self-represented because they have the tools, right? I think that there's this middle group of people that we see in court service centers and different folks that can utilize tools that are created that can help assist people fill out forms, give them self-guided documents and checklists and how to do different things. And then there's this population of people that need legal representation. They are limited in all variety of different aspects, and that's really where I see legal aid and legal services come in with that population of people, right? And so when I think of kind of the technology, it's really, what is the language access that is available for them? What are people comfortable with being able to use and not use? Is technology going to solve it from them? Can you imagine having a conversation with someone that is a child that has experienced sexual assault or there's domestic violence that's involved, asking someone to use a technology to assist them in drafting an affidavit to support the restraining order that they need, or doing a guardianship of minors while they're trying to handle the death of someone in their family, right? I think people come to court at really difficult times in their life, and there is a human aspect of the work that we do. And I don't think that AI or any technology can really replace the human component. I think that it's really to supplement and really help people that need help and provide services. I think our statistics say that we'll never be able to serve everybody, but I think this is where technology comes in, and being able to use technology to assist more and more people. I think things that Quentin has created, the MAID tools, the eviction tools, different things like that. You can put multiple people on the computer, you can do popcorn style, you can do a lot of things that create efficiencies, but I do not think that technology as a whole can really replace the human component for what people need. And how to make sure that we are not losing that in everything that we're doing.
I would say I consider myself a technologist, but not a techno-optimist, so I totally agree with that. I think there's a place for finding a human in all of these scenarios. That's really important. What we can do with technology is we can kind of lower that barrier of entry. We can lift people up to, okay, you can operate your smartphone, you can operate this tool. And there's folks who can't do that, right? That are still going to need that extra help. We try to think about the lowest common denominator. When we are building tools, we think about folks with a sixth grade reading level or below. We think about folks with different language needs, Spanish, other languages that we can translate into when we have that ability. I do think there's some interesting places where AI can help. I think that must have been Jen Howard who had said that from Rosie's Place. And I think letting people use their own words, their own language, that is something AI can do. We've seen that can help bridge that gap. People can talk about problems using their own words, and the AI can help translate into the way that the form needs it to be said. We can't do that with guided interviews, right? We have to think in advance what kind of questions, how people want to phrase things. We're working with a legal aid program in Virginia where we're going to do this all on the phone. So it's all going to be audio, and we're going to try to capture the information. We're seeing pretty good results so far. So it's not going to be everything. It's not going to solve the problem for everybody, but we hopefully can reduce the number of folks who need that high-touch care so that we have the right staffing, the right population of attorneys who can provide that help that way.
Yeah, I think we've all sort of touched on it, so I don't want to keep going, but sometimes it's just about diverting those simplest cases, right? So how do we divert the people that can use the technology tools to be able to use the technology tools, or the ones that need more technology tools like digital accessibility? You know, someone who uses a screen reader, you know, may or may not be able to get a form or get information when they get to the actual courthouse. So like, how are we diverting people in the right way, and then putting resources and prioritizing that? And then, you know, I sit in Springfield and I see the court service center with the line out the door the entire day. I don't see people ever going away. I think you're always going to need that type of help. I mean, this isn't, you know, we always talk about like, okay, how do you replicate Amazon, right? But this isn't like a low stakes process, right? So you can return things from Amazon. You can't take back some things on your filings. This has legal repercussions that are higher than that. But I think those technology tools are so great at getting the right people, if we can use them correctly, getting the right people and the right help.
Alrighty, so yes, we've danced around AI, and my favorite quote from a judge on one of these sanctions decisions about hallucinations, many of which are floating around, was, imagine the use of AI might just require actual intelligence instead of artificial intelligence. So can I invite the panelists to give one additional example of either where specifically AI is fitting in your work right now today, or where you hope it will fit in the next, say, 3 to 5 years? And also, what guardrails do we need to be thinking of with the hype, with the excitement, with the energy to kind of make sure we're keeping up?
I can start. I don't know, maybe necessarily call it guardrails, but thinking about kind of limitations to AI and really where we are technologically. And the analogy that I will use is AI is like the incredible flat screen TV that you have picked out and you cannot wait to hang in your brand new house, but you haven't even built the foundation and you haven't put up the walls. And so if you try to install that TV without a good foundation, without solid walls around it, it's going to fall off and it's going to break a bunch of stuff in your house. And we really don't want to do that with something as high stakes as the courts. So I think we're very excited about AI and the opportunities that it can bring, but I also think we need to approach it in a really thoughtful and meaningful way. In terms of what we see for the future, we think that there is, a lot of possibilities when it comes to assisting in some of the tedious and monotonous work that folks do that actually probably don't require a human. And it's not to replace humans, it's to allow those humans to spend their time on things that only humans can do in the court system. So that would be things like, checking that documents that are filed have signatures on them. If we can automate something like that, that means that that no longer needs to be the responsibility of someone, and that person can then spend their time working at the counter, engaging with folks who need their help in that high touch environment, not necessarily doing that kind of work day to day that we could automate.
I think it's all about augment right now where AI is, and I don't know for sure what will happen in 5 years. It's about augmenting, not replacing. So I think about safe uses as being ones where a human is going to have another look at that. Or if there's something, right now we're trying it out with drafting translation of our guided interviews. It's very expensive and time consuming to do. We have the AI create a draft. We have a human look it over before it ever sees the public's eyes. We use it to build first drafts of our guided interviews themselves now. We're trying this out too. So it's very, in some ways, mechanical to take a paper PDF and turn it into a step-by-step flowchart. But you can't just send that out and let people start using it. It creates a first draft. We have somebody take that first draft, they can run it, they can even do usability testing on it potentially, and then they know where it needs to be improved before it really is safe to be used. That's where I see it getting used the best right now. Other places can be where you're going to maybe help somebody polish up their phrasing to make it easier to understand or to tell a cohesive story. If a person can then see it and say, yeah, that is actually what I meant to say. I just didn't have the ability to put it into those words myself. So I don't think it's a good tool to use to write your brief yet, unless you want to get a big fine from a judge when it makes up some cases for you. But there's lots of ways it can help save us time.
I don't want to steal your thunder on forums.
Well, I'm not going to steal your thunder either, Charisse. We use it the way that Quentin talks about. We use it to help draft self-help materials as a first pass, and then a human reviews it. We use it to kind of get to those bigger points. I don't know if anyone's done this, but it's a great experiment. Take an old statute and throw it into ChatGPT and see what it comes up with. It's not bad. So it'll create some types of, distilled self-help materials, but that have to be heavily reviewed at this stage.
I think on the court for our operations, we don't use it much in terms of our kind of interface with court users, but I definitely see the future of it is creating efficiencies for us in the completion of court forms. Sometimes we have families that come in that need to do 4 guardianships, and when you're filling out 4 individual guardianship packets, it can take a really long time to do that. I think about, the website, and to some of the points of people don't always know. People come in and they know what they're trying to do. They don't necessarily know how to get there, right? So they don't always use the forms that are use the words that are written on the form. We say guardianship of a minor or guardianship of an incapacitated person. People say I need to get custody of my grandchild, right? And so kind of thinking about how do we use the common words that people use to help find the court forms on the website to be able to do the things that they need to do, or to find the legal resources, or to find court services, or find clerk's offices, and so forth. I think the challenge that we have, I love all the work on the e-courts and the forms and the things. My pet peeve, which you talk about in the Court Service Center all the time, is really the lack of uniformity across counties and across different clerks and registrars' offices. And I think I wish we could get, and my future hope is really that we can get to a place where we can establish some uniformity there, because I think that will increase the utilization of all these amazing tools that will eventually come and be available to assist court users.
Charisse, without putting you on the spot, can I have one quick follow-up to what you said earlier? Are self-represented litigants coming into the Court Service Center with AI-generated work product? Do you see kind of that as, dare I say, a trend compared to in the past when they might have Googled something? But is that kind of the next wave of how our court is interacting with folks that have already done what they think is their first ChatGPT go at it?
Absolutely, and Carolyn is here, and Sarah is here, and we take it from them because we know that it is wrong. I think our first interaction with kind of the things that were online, where we would have notarios, and they would charge people, and they would pull these forms off of LegalZoom, if anybody remembers that. So that was like our first thing that we would encounter. But yes, I think that Google something, and next thing you know, Gemini pops up all of this information. And yes, there's a whole host of disclaimers, but people don't know what they don't know. So they don't know if this is right. They don't know if it's wrong. People are using their, hard-earned money, their last oftentimes to draft these separation agreements that cannot be submitted into the court. So we see it all of the time, and I think it's a huge concern for us to be able to, but I also think I saw something that said ChatGPT said that they're going to stop giving legal and financial and health advice, which I think is a great idea. But yes, it comes up for court users. It definitely comes up for lawyers in the drafting of their documents, which we track certainly on the law library side in all of those cases. But it is real, and our court users are using it. And, I don't know how we regulate that, but it's certainly a concern for us.
So we covered that last week in my generative AI and delivery of legal services class, and OpenAI just amended their terms of service in the fine print to say, hey, no one should use this to deliver legal advice, but I hesitate to think that's going to stop the public from engaging. So another topic besides AI that we love to hate and hate to love is money. We all are juggling so many allocation of resources and priority and decisions. So thinking about the next 10 to 20 years, future investment in this space, take money off the table or keep it on as you may, but what comes next and what criteria should guide that, and what is our wish list as we think about the next 10 or 20 years of investment here?
I can go ahead just from the IT perspective.
You need a lot of money.
We do need a lot of money. No, I mean, I really think it's, I'm going to start to sound like a broken record here. And if you heard Steve's presentation earlier, you probably kind of caught this as well. Really making sure that we're investing in our base foundational systems, making sure that those run smoothly and that those can handle the increase in volume that I anticipate will only grow. And probably the only other person in this room who loves numbers as much as I is Lee, who gave you a lot of statistics earlier. And I will give you one set of statistics related to the number of documents that we received electronically. So in 2021, just 4 years ago, we received roughly 665,000 documents filed across the trial court for that year. In fiscal 2025, we were close to 2 million. So in 4 years, we had that massive increase. We need to make sure that our systems are capable of handling the volume and the strain that comes along with that, because that's only going to continue to grow. And that may seem like it's not very flashy, but it's incredibly important for the court system to be able to maintain that level of offerings and services to everyone. And it's really integral to the work that we all do day to day to kind of keep things moving. So that's where I would say we really need to continue to invest the money.
I need all the money. I think that just kind of reiterate a point is that we need more of the eviction sealing petitions and a lot more cases that can then be interpreted into, translated into more languages, right? And so a lot of that is very, very expensive to do. We need uniformity, which is on the back end, very expensive to do if you're a court leader and trying to kind of get, folks into that space of being able to. I think we need to think about the court user and create court user human-centered platforms, right? People are using their cell phones, whereas mobile optimization, and all of those different things, and I think that we have to figure out how to add more technology, more computers, more partnerships, and more of those things, which is also very, very expensive to do. But lots of money is needed.
To say, like, wearing my legal aid attorney hat, I think the biggest money gap that we have is the fact that if you roll a dice, you have to roll like a 1 or a 2 to get a legal aid attorney, even if you qualify for one. So I think that's really shameful that in this Commonwealth, we're very wealthy, we can't provide people who qualify for legal help an attorney. That's, I think, the baseline. That's probably where I should stop too, because I think that's the key.
You know, I really think language access is somewhere where we are just exploring technology, solutions that I would put some funding towards. More interpreters, more translators, people that can help people in their own language. That would be incredibly helpful both for users and for the court. I'm a little bit like Charisse, where I would take all the funding also, but I really think that that's somewhere where we can make a difference with some additional funding.
Alrighty, we have about 5 minutes left, so I'd like to start to wrap up and ask our panelists to get out their crystal balls for a minute. And I'll ask two sides of the coin. We're here for the 20th anniversary, but if we look ahead and think big, I'll let you choose. You can choose your own adventure here. The pessimists could comment, please, on the biggest risk that we're facing in this space in the next 10 or 20 years. And the optimists among us, and feel free, you can fight the hypo and do both if you want, as we say in law school. What is one bold goal? So if the commission sits down today and says, in 20 years, we want X, or we want to be where, what does that goal look like? And what do we talk about in 20 years? So you can choose both, you can choose one, and we'll wrap up with those big crystal ball ideas.
Nobody wants to go? I'm actually going to go. I really loved Lee's presentation. To hear about what we were talking about in 1995 that we're still talking about, the topics that we are talking about today, we're going to be talking about in 20 years. So that's my crystal ball. And maybe I'm on the more pessimistic side of that. And I'll say, I think one of the biggest risks is AI. Where does it go from here? It's sort of like a limitless whatever. So that would be my two.
I don't think we have to go 20 years, but I think the first thing we have to recognize is what Charisse was just talking about, where folks are showing up to the courthouse with these AI-generated pleadings. We don't really have anything else to give them. We can't give them an attorney. We can't give them a form they can fill out on their own. So I think we need to figure out how to address that challenge. I think there are ways we can do that. We can help give them more help. I think AI could be part of that solution, but we need to invest the money and time to actually be able to deliver on that promise.
I don't know where. I'm everywhere. I think there's to Emily's point that, having the same conversations and being at the same place and still feeling like there's a lack of progress, I think is one of the biggest concerns. I've been at the court for 10 years and I've been asking for uniformity for certain areas for us. And so I think for me, I look at other states like New York, where there is kind of a uniform court system, which then lends itself to being able to do certain things. And I think that that is a hard push for 20 years, but I definitely think that we are at a place where we could push a little bit harder on particular areas that we know are case types that are heavily used by self-represented litigant populations, and get to a place where we can leverage the tools that we do have with money, of course, with money. But I would say that that's really kind of what I would, and then accountability. I think that there has to be a lot of the Access to Justice Commission of holding a court accountable. I think Lee talked about that a lot. That is really, really important, is to, to hold the institution accountable for actionable items and to really get progress on things that have been conversations over and over and over again.
I think for 20 years, my hope would be that we are in a much more digital place. We could walk into a clerk's office in 2045 and maybe not see rooms and rooms of paper files. That's probably not the safest way to store all of this court information. Technology has made it cheaper and faster and better to store it differently, and I think that we can get there. But I also think that we have to be patient, and we have to recognize that there will still always be folks who prefer paper, and that's okay. But can we reduce what we're using? Can we make it a little bit more digital? Can that be sort of the presumptive means of how we use information? And maybe the exception to that is the paper that we can provide, or that, you know, someone could provide to us. So that would be my hope for 20 years, certainly. And if we can do it sooner, all the better.
Panelist says realistic optimists. So we appreciate that forward-thinking positivity. And I'll thank our panelists by reiterating the quote from the video we saw earlier from Nelson Mandela, that it always seems impossible until it's done. So I look forward to the conversation in the future and seeing what we can do, and thank our panelists for being at the leadership helm of that effort.
Well done. Well, that was a lot of great food for thought, and we're going to wrap up. Before we do, I want to remind our Access to Justice Fellows to come forward for their photo. And again, we're here for celebration, but we're also here for challenge. Technology, I worried, was a bit of a wonky topic for a celebration, but we went with it because we really do think that it is one of the key topics that we must grapple with in the civil justice access, in the civil justice system, as we think about access to justice. And we heard a lot about the imperative to modernize and digitize our civil justice system, but I was very heartened that we also heard about the need to focus on to what end. It's our values that are going to ultimately dictate where we go with technology and where technology takes us, and whether technology is going to turn out to be the great equalizer for us in our justice system, or a great divider that only exacerbates the barriers and the ability of people to get what they need from our justice system. So I like the clear-eyed realism and the pragmatic optimism that I think we heard today. I think the subject for our policy makers, and when we appeal for the money that the court system is going to need to do all of these wonderful things and to save us from all these terrible things, we are going to have to bring great clarity of purpose and imagination and that sense of practical optimism. So with that in mind, let me tell you, thank you for getting through a 3-hour tech seminar on a Monday afternoon, and to congratulate all of you and to inspire us further. Right after this, we're going to repair to a reception in the conference suite on the second floor, right down the hall and around the corner, where you can chat and have some refreshments and contemplate all that you've been given to think about today. So on behalf of my co-chair, Judge Eurasius, and everyone on the Access to Justice Commission, thank you all very much. And the program's complete.